You just found the perfect home. Great neighborhood, great price. You make an offer, it gets accepted. You move in, and then you discover the basement floods every time it rains. The seller knew and said nothing. So what happens now? And more importantly, how do you make sure this never happens to you? Today we are breaking down exactly what sellers are legally required to tell you before you buy a home. This is information that could save you thousands of dollars and a massive legal headache. Whether you are currently house hunting or just want to know your rights, stick around. This one matters. Let us start with the big picture. In most states, sellers are legally required to provide written disclosures documenting material defects. That is a fancy way of saying anything that negatively impacts the value of the property or that a reasonable buyer would want to know before purchasing. This is not optional. This is the law. And here is something that surprises a lot of people. Even in states that follow what is called caveat emptor, that is Latin for buyer beware, sellers are still not off the hook. Caveat emptor does not mean sellers can hide known problems from you. Fraudulent concealment of major physical defects is illegal in virtually all states. So even in states where written disclosure forms are not required, a seller who deliberately hides a serious defect can still be held legally liable. The buyer beware rule has limits, and one of those limits is that sellers cannot actively deceive you. Now let us talk about timing, because this part catches a lot of buyers off guard. Generally in most states, after a seller accepts your offer, they have somewhere between 72 and 120 hours to submit their disclosures to you. That window starts ticking the moment the offer is accepted. So if you are a buyer, do not assume disclosures will just show up whenever. Know your contract. Know your timeline. Once you receive those disclosures, you typically enter what is called an inspection period. This is your window to dig deeper, hire inspectors, and ask questions. If you submit a repair request during that inspection period, the seller generally in most states has 120 hours to respond to that request. They can agree, they can refuse, or they can negotiate. But they cannot just ignore it and run out the clock. That 120-hour response window is there to keep the process moving and protect both parties. Here is one disclosure that is not just a state law issue. It is federal law. If a home was built before 1978, the seller is legally required to disclose any known lead-based paint hazards. This comes directly from the Residential Lead-Based Paint Hazard Reduction Act of 1992. Sellers must use EPA-approved forms and provide buyers with an EPA-approved pamphlet explaining the risks of lead paint exposure. And as a buyer, you have rights here too. Once you receive that lead paint disclosure, federal law gives you 240 hours to conduct a lead-based paint inspection if you choose to. That is your protected window. You cannot be rushed out of it. Some buyers waive this right, but you should know it exists before you sign anything. So what kinds of things are sellers generally required to disclose? Under most state laws, the list is broader than most people realize. Sellers must disclose completed repairs, meaning work that was done on the property, even if it looks fine now. They must disclose natural hazards like flood zones or earthquake risks. They must disclose property defects, missing essentials like a non-functioning heating system, and land use limitations that could affect how you use the property. If the home is part of a homeowners association, that information must also be disclosed, including any fees or rules that come with it. Sellers must also disclose conditions that affect property value in ways that are not immediately visible. And here is one that surprises people. In many states, sellers are required to disclose deaths that occurred on the property. The rules around this vary, but if this matters to you, it is worth asking directly and checking your state's specific requirements. Not every state plays by the same rules, and a few specific examples are worth knowing about. In some states, there is no requirement for a comprehensive written disclosure form, but sellers are still legally liable for fraudulent concealment or misrepresentation. The absence of a required form does not give sellers permission to hide known defects. In one state, the caveat emptor rule applies broadly, but there is a clear exception. If the seller knows the property has a health or safety issue, they are required to disclose it. Buyer beware does not mean buyer in danger. In one Western state, sellers are specifically required to disclose whether the property was ever used as a methamphetamine lab. This is a contamination issue that can have serious health consequences and is not something a standard inspection would necessarily catch. It is a good example of how regional and environmental disclosure requirements can vary significantly depending on where you are buying. And in one large coastal state, after receiving disclosures, buyers have 72 hours after personal delivery or 120 hours after delivery by email or mail to cancel the purchase based on what the disclosures reveal. That cancellation window is a built-in protection worth knowing about. Here is how this plays out in real life. A buyer purchases a home and moves in. A few months later, they discover serious water damage hidden behind recently installed drywall. The seller had completed repairs but never disclosed the underlying moisture problem. Because fraudulent concealment is illegal in virtually all states, the buyer has legal grounds to pursue the seller. The disclosure law existed to prevent exactly this situation. So here is your takeaway. Read every disclosure document carefully. Ask questions. Hire a qualified inspector. Know your timelines. And if something feels off, talk to a real estate attorney in your area before you close. If you found this helpful, give this video a like and subscribe to know the law. Drop a comment below if you have a question about your situation. We read every single one.